All right, welcome back to Stopping the Who. And this story from the Defender and the Brownstone Institute, it will boggle your mind. We are under full assault here in this country, our rights and our civil liberties. Okay, so Vermont Supreme Court said what? Yep. A controversial Vermont Supreme Court decision reached the rather astonishing conclusion that the government can vaccinate very young children with experimental products without parental consent or legal recourse. The ruling is surreal in a state that claims it prizes individual liberties. If not overturned by sane minds in the U.S. Supreme Court, the consequences of this short-sighted, simplistic opinion may prove profound for American civil rights law. Dario and Shujin Palatella versus the Wyndham Southeast School District, which concerned a young child who was administered a COVID-19 vaccine despite his parents' prior communication to their local public school that he was not to be vaccinated. So here you are trying to be a good parent and have good communication with the school. And they said, please do not vaccinate the student. So what did they go out and then suddenly say? Well, here's one that we need to vaccinate because the parents don't want the kid vaccinated. The boy told the workers his parents objected, but they distracted him with a stuffed animal and administered the jab. These people are absolute criminals and monsters, in my humble opinion. The Vermont Supreme Court ruled that the Public Readiness and Emergency Preparedness Act, or the PrEP Act, immunized, great word to use, right? Immunized school officials from all state law claims as a matter of law. So because of all of this money in the PrEP Act and how the PrEP Act was worded, is the PrEP Act law in and of itself? I didn't know the PrEP Act came with some kind of new legal code that stopped any sort of legal action. This is insane. The court did not address state or federal constitutional privacy protections or bodily autonomy. No, because the PrEP Act trumps any laws that are currently on the books, apparently. This is insane. Particularly callous toward parents whose children might be vaccinated or vaccine injured by negligent or incompetent medical care was the Palatella's court construction of the PrEP Act to extinguish informed consent. And this, obviously, with regards to minors, despite the act lacking any such stated intent. So the PrEP Act, which again doesn't address legal issues, doesn't say that this would extinguish informed consent and not to allow informed consent. To rub salt in this civil rights wound, the court interpreted federal PrEP Act preemption and thus immunity to include even experimental vaccines, regardless of efficacy, future vaccine injury, or a balancing of potential benefits versus harms to children. So they don't care if it works or not. That's not their concern if it works, because they all work. They're all 100% safe and effective. So there's no reason to even get into this. The court reasoned that because the sole exemption to the PrEP Act's grant of immunity is a federal cause of action against a covered person whose willful misconduct causes death or serious physical injury. So the plaintiffs here required a showing of one of four possibilities that would exempt them from the Act's vaccine litigation shield. So this contention, now try to follow this. The Act itself is a bulwark. I'm not sure what word to use here, but it just because it was passed, you can't sue anybody because of this act. This is like another 1986 thing. This is incredible. So the only way that you could sue or counter complain or whatever it is, file a complaint against this is a defendant wasn't covered. Okay, that's number one. Two, a defendant's conduct was not causally related to administering a covered countermeasure, that is, a medical or other PrEP protected person did something other than give a shot. Okay, I'm not sure what that means. I mean, if they hit you over the head with a baseball bat, that wouldn't be covered. All right, that wouldn't be included. The injected substance was not covered by the act. Well, it would have to be something other than these safe and effective products, right? And the sarcasm I continue to use is to help fight censorship, but who knows what will happen with this video on certain platforms. The PrEP Act declaration had expired. So if the only way that they get around this is if the PrEP Act was no longer, and is it still currently in effect right now? I have no idea. Apparently in Vermont, it still is. This construction of federal law allowed the court to dismiss the Vermont parents' concerns that the vaccine they asked not to be given to their young son was experimental, concluding that even a poison vaccine would still merit congressional protection under number 2 above. So it just was not causally related to administering a covered countermeasure. That is, a medical or other PrEP protected person did something other than give a shot. So the shot was permitted under the PrEP Act. So the only way they wouldn't be covered is if they did something other than give a shot. I'm just trying to, as I read this, I'm trying to figure it out. It's not easy. And this is why people completely tune out and give up on this stuff. Despite plaintiffs' arguments to the contrary, they have alleged only tortious conduct is causally related to the administration of the vaccine to their son. Plaintiffs characterize the blah, blah, blah as experimental, but they do not dispute that their son was injected, nor do they dispute that the safe and effective product is a covered countermeasure. Translation, thank you. The Vermont Supreme Court construes evidence that clearly proves that an approved vaccine is experimental, harmful, ineffective, or even deliberately designed to inflict illness, so long as it does not result in death or serious physical injury, to defeat any claim because all of these factual allegations confirmed a covered shot was administered, which bars all claims short of planned genocide. I don't know if I want to continue with this. This decision reverses a century of medical ethics, concluding that PrEP Act immunity also extends to children separated negligently or deliberately, the latter only being actionable if death or serious injury results, from their parents and denied long-standing parental informed consent protections. So without digging even further into this, I'll post a link to this article in the description of this video. They're basically telling you there's nothing you can do to fight the PrEP Act. because the PrEP Act determined who could be sued and under what circumstances. And this child is not covered, and these parents have no standing because of the PrEP Act. Now, this is apparently going to the Supreme Court, and we can hope that the Supreme Court takes a look at this and votes 9-0 that this is complete insanity and tyranny and constitutes all manner of violations to our Constitution and to bodily autonomy. This is insanity, folks. And this is the road we're headed down if Kamala Harris wins the election. And I'm just saying, and after watching the convention and so forth, there are a lot of people who wouldn't think twice about sending little Johnny to school in Vermont and thinking that these people have his best interests at heart, when quite frankly, they are some very evil people to distract a little boy with a teddy bear so they can inject him. That is just, I don't know what to say about these people. I think I'm just going to stop talking. Thanks for watching the video. The Buy Me a Coffee link will also be next to or underneath the link for this article. If you can help support this channel, the algorithm is going to destroy this. And also, there's a good chance on certain platforms that this could be blocked entirely. So please support if you can. You can watch this also over on Odyssey and BitChute, Rockfin, Rumble, Brighteon. There are a number of places to see this channel in case this video is up and then it goes missing on YouTube.